Stevenson versus City.
May it please the Court. Jonathan Cooper for the plaintiffs.
Got you on a rebuttal time?
If I could have 2 minutes, please.
Sure.
Thank you. At the outset, let me be clear. We're not seeking an expansion of school liability under New York law. We're only asking that this Court apply existing law to this case. It's the city, with all due respect, that is asking this Court to shrink considerably.
What's the proximate cause as to what happened here?
The proximate cause?
Yeah.
The school's failure to inform the mother is the...
There's no intervening event?
No, this was a foreseeable event. The foreseeable event was that...
Foreseeable that a kid outside of normal school hours, outside of school grounds, would pick that day to attack the other student?
Not necessarily that day, Your Honor. But this is...
Why couldn't it have been 6 months later that he did it? And would that have been foreseeable?
I readily concede that as the timeline extends, the causal link and the proximate cause link actually does become more tenuous. And at some point down the line, a court would be obliged to step in and say that, no, that couldn't be, this event could not cause this infant's injuries. But that's not this case.
So you say that the school may have a duty here because it was foreseeable, it was close in time to the first attack, and therefore liability. In fact, what the dissent said.
Yeah, absolutely. Yeah.
They have a duty even though they didn't create the danger, or they dealt with it or felt that they dealt with it.
Off school property.
Well, yeah, they dealt with it, but that goes into the second issue, which is...
I mean, they're not the insurer of the kid's safety, right?
I'm not saying that they're insurer of the kid's safety. All I'm saying is they have a duty to notify the mother. Don't take it out of the mother's hands.
What's the duty come from to notify the mother?
Common law. Common law.
What if instead of being on their way to school the next morning,
Right.
the next morning was a Saturday and he was on his way to go to the movies someplace else in the city, and then he's jumped? The school is still responsible because they had a duty to tell the mother?
In my view, yes, Your Honor. When it's that close in time...
That's not extending the rule beyond?
I don't think so, Your Honor. The question is...
This is a black and white rule that says what?
The school has a duty to undertake reasonable, adequate measures. I'm using this Court's language from Morant. Adequate measures to protect the children when a threat comes to their attention during school hours.
And informing the mother about what happened would have been adequate to protect the child?
I think so, Your Honor, yeah. Had they picked up so much as picked up a phone and called the mother and said, we want you to be aware, Ms. Sinclair, that there was an incident involving your son today at school. Perhaps you want to come in and discuss it. There is an additional threat, and that's the law of this case, which wasn't appealed, that we're aware of. We just want to make you aware so you can undertake whatever measures you deem appropriate. If that had happened, I lose.
Your rule, if I understand it, and maybe it's right, is that when one child threatens another in school and the school knows about it, and the school handles it in a way that it fails to exercise due care, whatever due care is in dealing with it, then the school is liable for any, if the one kid later beats up the other, no matter where.
That's correct. That's correct.
And for how long would...
When it gets to that issue of proximate causation,
I
over a certain amount of time...
I realize this was the next day, but what if it's 2 weeks later or a month later?
Quite frankly, I don't know where that line is drawn, but what I do know is it shouldn't be decided and dismissed as a matter of law. In this case, after 2 days.
Won't this have tremendous implications? You know how many scuffles there are every day in schools, around this state and beyond? Isn't that an awful expansive rule? Isn't that going to have tremendous impact on schools and school districts?
I don't think so, Your Honor. If it was a question that, as the city urges
in their scuffle, they have to tell the parent this is a danger.
It depends on the severity of the scuffle as well.
But now the rule becomes more complicated. What's the severity? Where do you draw the line as the severity of the scuffle?
That may be a fact and case-by-case inquiry, Your Honor. In this case, the school felt it was at least sufficiently severe that they imposed a 1 to 2 week suspension on Mr. McDonald. So obviously they didn't think this was nothing with nothing.
Well, but the victim had a 1 day in school.
Because the school administrator felt he wasn't as much at fault. He did throw 2 punches, but he wasn't as much at fault. He didn't instigate it, and that's why they only gave him 1 day as opposed to 2 weeks. Additionally, it appears, although we only have partial, the city didn't provide the records on this, Mr. McDonald did have a disciplinary history. The extent of it we'll never know because they lost or destroyed those records. Another point I wanted to make, which is, and I think an important point, is that what the majority did in the court below is they essentially had a carve-out, immunizing the school against any inquiry into the adequacy of whatever disciplinary measures they mete out, whatever protective measures they mete out. Tellingly, the majority doesn't cite any case law for that proposition, and I suggest that that's actually directly contrary to this Court's expressed language in Morand. Moreover, the notion of notifying, having to notify a student's parent is not without precedent, not within New York and not outside of New York, based on the cases I cited in my brief of Ferraro, as well as the case from California that was initially brought up by Justice Sachs in the court below of Phyllis v. Superior Court. And those cases I submit are pretty much directly on point and relevant to this case, where the Court said it's the failure of the principal to have alerted the substitute teacher, thereby depriving her of the opportunity of using her own judgment, which I believe constitutes the act of negligence in this case.
Of course, it is important for principals and teachers to use their judgment, isn't it? Isn't there a danger that the more you expand this kind of liability, the more the schools and people who run schools are going to be worrying only about, am I going to get sued? There's going to the schools are going to put in a policy and say, you hear one kid raise his voice to another, you've got to get on the phone with the parents because we're going to be liable. I mean, doesn't this become a problem for the functioning school system?
In theory, if it's something that is so utterly minimal, yes, but that isn't this case, Your Honor.
Can you explain what happened to me with the discovery sanction?
Sure. What happened was, over a series of years, beginning in July of 2004, we made demands for certain records from the city pertaining to the assaulting student, Mr. McDonald, as well as the school's investigation and what they learned about both the incidents, the beginning of the incident on October 22nd, 2003, as well as the threat on October 23rd, and the ultimate culminating incident on October 24th. And the school didn't even bother looking for those records for a period of over 4 years, by which time that school closed down and all those records were lost. And therefore, Judge Schaffner in the Bronx issued an order dated December 2nd, 2008, which said that, therefore, as a sanction, the issue of notice.
Notice is out of the case. We have to.
That's correct.
Okay.
And no one's really debating notice now. And so this appeal doesn't turn on that discussion.
Well, they tried to bring that in a little bit, Your Honor, but I don't believe it's an issue on this appeal.
Okay. You'll have rebuttal.
Thank you.
Counsel.
Why shouldn't there be a duty here?
It's well established in the law, Your Honor, that the school's duty is limited. It's a duty of care limited by time and space, and only so long as the students are in the custody and care of the school on school grounds.
Counsel, don't you think in a normal situation when your child is suspended, even in a house, that the school would notify the parent?
Not in this case, Your Honor, only because the school...
No, I'm asking you in general. Wouldn't you think that the school would notify the child's parent that your child has been suspended for a day or whatever it is?
Not necessarily, because as this Court recognizes...
And in the same incident, another child's been suspended from school altogether for whatever it is.
It places too unfair of a burden on the school.
What do you do when you suspend somebody but don't tell the parents? You just say you can't come to school tomorrow?
Well, in this case, Javon did attend school.
No, I didn't ask you that. You said you don't have to notify parents if you suspend a child, a student. So my thought is you tell a student, you can't come to school tomorrow. Now, let's assume he's immature and says, if I tell my parents this, I'm in real trouble. So I won't tell them. Does that mean that the kid can just tell his parents, well, I'm on my way to school and head someplace else?
I'm not familiar with the full range of disciplinary.
Well, I'm asking you, if you talk about your client. I mean, your client here, you're saying that your client has the right to take an 11, 12, 13-year-old child and put them on the street and not tell their parents.
In this case, I only know that.
No, I understand you want to say in this case that didn't happen, but you're basing your argument on the fact that you have the absolute right to take a minor child, put him in the street, and not tell anybody. I just find that's surprising. I would think you would say, of course, we have a duty, and in this case, it didn't. The duty didn't arise or something. But how do you do that? I would be shocked if my kids were going to a school where the principal or the superintendent said, and by the way, if your kid acts up, we're putting him on Delaware Avenue. I'm in Buffalo, and how he gets home is his business. If he finds you, that'll be great. If he doesn't, it's not our fault.
I would imagine that there is a duty to notify in the case that a student is told not to come to school, that he's suspended for outside of school.
That's what I thought you'd say in the first place.
No. Oh, I'm sorry. Then I misunderstood. But in this case, I don't really understand. I mean, as far as we can tell from the record, the assistant principal, Reed, in this case, made a determination that Javon should be suspended one day in school and that he served his suspension in the basement, that he did his regular class work, and that he was provided with work to do. I don't know about situations where a student is told not to come to school.
I mean, he was separated from his classes, but he was still in the school building during the time of his suspension?
From what I can tell from the record, that's my understanding, that he was given classwork, but that he did not attend his regular classes. And he also testified at his 50H hearing.
So he was like in detention?
That's probably a fair analogy as to what happened.
I mean, is it a fair statement of the law, as you see it, that the school's duty extends as long as the child is in the school and until the child is released to a place of safety?
I think that's an accurate statement of the school's duty.
Yeah, and there are cases where the school has been held, where the injury was off the school grounds, but that was generally where the school was at some form of the actual release of the kid, right?
I think an example of that is in the Bell case. In the Bell case, there were several classes that attended a fair in the park, and the teacher, the school was responsible for the children while they were in the park, and then when the children were with the teacher and they went back to their school, the class left without one student. When she was looking for her class in the park, she couldn't find them. She proceeded to walk home alone, and she was about a block away from the park when she was accosted and raped. And in that case, this Court found that the rape was a foreseeable consequence because the duty in that case was shaped precisely by...
The duty there was pretty clear. You can't lose a kid. You're not supposed to do that. The problem in that case was a proximate cause problem. Do you agree?
Well, but there was also a duty of supervision, and that the teacher failed.
But I think it would be very hard on the facts of that case to argue that the school didn't breach any duty. You might argue whether the breach of the duty led to the particular harm. But here, it's just more the other way around. You're saying we don't get to proximate cause because there was no breach of duty in the first place.
That's correct. There was no duty. I think it's really important for this Court to understand that the incident, there was a scuffle in school between classes, and the incident ended. Javon went to the very next class. He was taken out of the class, and he was brought to see the assistant principal. She interviewed both students. She determined upon the other student's admission that he had started the fight. She determined to mete out punishment, and then she staggered their dismissal so that Javon was released early from school that day to avoid any further encounter.
Putting aside the duty issue, could she not be found negligent in not making a phone call to the mother?
No, because I think that the school administrators need to have a certain flexibility, and there are scuffles between students that happen all the time. And in this situation, the principal interviewed both students, and she was entitled to the discretion to make a determination that this incident is best resolved by suspending both students. In this case, apparently Javon for one day, and for the other student a week or two.
Suppose the facts had been she had the fight happened, the encounter happened, she calls them in, she makes them her speech about how they both misbehaved and one is worse than the other and you're suspended for one day and you're suspended for longer. And then she says, okay, goodbye, boys, and lets them both go out unsupervised into the backyard where the bigger one beats the little one up. Is the school liable for that, for her misjudgment in doing that?
And the assault happened where? On school property?
Immediately. As soon as they're out of her sight.
Perhaps an argument could be made that, the incident spilled over, but I think here there was a complete break. I don't even think that you can make the argument that this was any kind of a continuous incident. I think that it was addressed, it ended, a day passed, and then the assault happened more than 2 blocks from school property.
Mr. Cooper relies on our Miranda case, and of course, in there we talked a lot about notice, but you've conceded that you had notice. And then we say...
well, but may I just interrupt, Your Honor?
That is that the third-party acts could reasonably have been anticipated, and the school's negligence must be the proximate cause of the injury.
I just wanted to make one point about notice. I mean, in this case, unfortunately, it was a harsh discovery sanction for our failure to turn over records. We're stuck with it. We can't... Right. There's nothing...
But you had notice.
But it's a fictional situation that was created. I mean,
well, not really, because I think the reason that sanctions happen, if I remember my experience, is so that they don't happen again. And what generally the court's thinking is, you really did have notice. You don't want to admit it, so you're not turning the records over. So we'll solve that problem for you and prevent you from putting in any documents that otherwise would have shown notice.
I think there is a significant difference, because in this case, nobody's saying that the principal or anybody in the school knew that this assault was going to happen 2 days later on a street corner when he exited the subway.
Well, no human being could possibly have known that. But on the other hand, it would be very hard to say that the school wasn't on notice that there was some little tension between these boys.
Tension doesn't necessarily...
Some violence, that there had been violence between them.
There could have been a note from one person to another saying, if we don't do something, this is going to evolve into a very serious situation, perhaps even outside of school.
This was a vicious, planned, targeted attack. I mean, he brought 4 friends...
Picture that note. That's why I think, you talk about harshness of the preclusion. Somebody could have said, I'm afraid there's going to be a vicious, planned attack on our student, so we got to do something. But you won't turn that over, so the judge says, I'll take care of it for you.
Unfortunately, we don't know what records existed.
Exactly, but you can't keep saying that, because if you turn them over, you can say anything you wanted, it's in the records. But because there was a note that said exactly what I just said, which is, we are afraid there's going to be a vicious, planned attack on this, you want to deny that's true. You can't, because you refuse to turn over the documents. Isn't that what preclusion means?
But there's still no issue. But there's still no duty here in this piece, because even as the majority recognized, even had the mother been informed about this, it's completely speculative that she could have done anything to prevent the attack.
That's what Mr. Cooper's saying. It's a proximate cause issue and a question of fact.
But as the majority recognized, it's not even that. I think on this record, this Court can uphold that the appellate division got it right. They found that we were entitled to summary judgment on 2 grounds.
If you assume a duty, is it really, assume that there was a duty to make the phone call that was breached. I understand your argument is the contrary. But if you assume that they had a duty to make the phone call that was breached, is this really such an unforeseeable consequence of that particular breach of duty? Isn't that the whole point of the phone call, was somebody might beat the kid up?
It was completely unforeseeable. This was a minor scuffle that happened between class periods.
The other kid got suspended for how long?
According to Jay Vaughn, he heard the assistant principal say a week or 2.
That's not a minor scuffle. The kid gets suspended from school for a week or 2.
Because I think that after interviewing both students, the assistant principal determined that he had started a fight.
Right, but it's not a minor scuffle if that's not. You get into a little scuffle, and one kid started it, they break the kids up, and they go about their business.
It was a very short duration. It was between classes. Jay Vaughn's friends...
The kid got suspended for a week or 2. Assume that's the case.
That was the principal's judgment.
Okay. Thanks, Gus.
Thank you.
Counsel.
Thank you. I just wanted to make one really quick point, which is my adversary was pointing out that what the principal's judgment was. We don't know the basis. We don't know what her judgment was. We don't know what the basis for it was because, again, these are all records they never turned over. We have nothing regarding the investigation of either incident. We don't know, in fact, if there was one. We don't know what she determined, what she didn't determine. So to say that...
Did any depositions ever get taken?
No. No, because there were no records upon which to conduct
People
that.
have taken depositions without records in the history of the world.
That's true, Your Honor.
I mean,
But in this case...
did nobody call up the teacher and say, hey, you remember the Stevenson kid who got beat up? Tell me the story.
I don't disagree with what the Court's saying, but no depositions were taken, other than the 50H of my clients. The other issue I wanted to point out is, again, I don't think under these particular facts, the notion of a principal having to lift the phone receiver and just reach out and call a mother is some extraordinary burden. Far from it. When there's an incident that has a severity that involves suspension of 2 students, including one, the offending student, Mr. McDonald, for 1 to 2 weeks, to pick up a phone and say, we just want to make you aware, Ms. Sinclair, there is such an issue, and by the way, there was also another threat which we had notice of. So this wasn't just one isolated incident. There was also a threat where he says, we're going to get you jumped. To say to pick up the phone, I don't think is unreasonable at all.
Okay, counsel, thanks. Thank you both.